Good morning, everyone. Good morning.
You good there?
All right. Thank you for traveling in the what's now known as winter in New York City. Boy, was it cold. Thank you for being here. My name is Gregory Carlson. I'm the Executive Director of the New York AMA, and I want to welcome you here. I just want to say we're also in the middle of rewriting our website, and I know sometimes when you register for our seminars it gets a little crazy about confirmations, but we're going to a modern day platform, so to speak, so that when you do register in future seminars, you'll get an automatic confirmation that you have registered. All right, now we have to do it manually, so I'm looking forward to that. Without further ado, I would like to introduce to you New York AMA's President, Hunter Cushing.
Thank you, Greg, and good morning to everyone here live with us and also online. We welcome you to this extremely important seminar on REAC appeals. I don't think there is anything more important for an owner or manager of affordable housing, other than rent increases, than winning your appeals if you didn't get a score that you believe is justified. But before we get into our panel, for those of you, because I know we have some people with us and online that are not NYAMA members, I would like to take a moment to tell you a little bit about us. NYAMA is an affiliate of one of the two main trade associations for the multifamily affordable housing world, owner-operator world. And we have about 300 members representing 90,000 multifamily units, HUD-associated units in the New York hub area. We've been in existence a little over 6 years now, and we concentrate on really two different things. One, bringing you information that we think you need, such as this seminar, on how to work with HUD, the latest. The other thing we do is represent you through a dialogue with HUD and other regulatory agencies. We meet quarterly with Teresa Baden and her chiefs here in the New York office. We also meet quarterly with CGI, the contract administrator, and on an as-needed basis with NYCHA, HPD, HDC, and HCR. And we've built a very good relationship with them because the same 4 or 5 board members, called our core group, constantly meets with these agencies. So over the years, we've gotten to know one another, and it's not reinventing the wheel. So we really discuss issues that the agencies are proposing, how they will affect the industry, or issues that they have already put out, maybe without consulting us, and seeing that there are little glitches in the way that need to be corrected because of adverse impacts on the industry. So that's what we spend our time doing. And we are growing. This seminar is specifically HUD-based, but thanks to our executive director, Greg, who you met, who comes from a different world than those of us that are pretty much exclusively in the HUD world, in the New York City world. We've expanded to give a lot of seminars on non-HUD related issues. One of those will be our January seminar, I think, on energy efficiency and some of the New York City rules on that. So that's what we do, and if you're not a member, please, we have pamphlets out there, please join. We put out a quarterly newsletter. If you're not a member, you get discounts as a member to these seminars. And it's very worthy because we get our power, really, for the industry, with the agencies, from you, from how many members we have. So when we go in and talk to them, we're not talking as David Buckwalter or Hunter Cushing, former HUD people. We're really talking, saying, we represent 90,000 units of affordable housing. And that's why we get the commissioners to come speak to us at breakfasts and seminars from New York City. That's why we get people from Washington HUD coming up to speak at our regulators conference and otherwise, because they know that this is a large cross-section of the industry that they need to represent. So that's the pitch. Please join. And without further ado, what's important to our board is the person I'm going to introduce, who's going to be the moderator of this program, and that's David Buckwalter, who many of you may know from his many years as running asset management at HUD in the New York office. He kind of knows the ins and outs and keeps us on the straight and narrow. So, David, it's all yours.
Well, thank you, Hunter. Good morning, everyone, both here and on the web. My name is David Buckwalter. I'm president of, I should say, managing member of ADCAR Associates. We're a consulting firm. We focus in on HUD-related day-to-day management issues such as Section 8 renewals, management review preparation and appeals, troubled project, we help negotiate workouts, and we also do a lot of REAC work. We do pre-REAC inspections. We shadow the REAC inspectors for our clients, and then if the client does fail or otherwise needs an appeal, we'll do the appeal for them. I'm joined for this presentation by Bill Eaton, who is from New Jersey. He is a property owner. He has several HUD-related properties. He also has a legal practice focusing in on, among other things, HUD-related issues. And he'll tell you a bit more about himself and his background when he gets up, but I think he'll be giving you a very interesting presentation. Basically, what I'm going to do is walk you through some of the technicalities. I'm going to do the boring part. Then Bill is going to entertain you, or, and I've heard him speak before, perhaps regale you with some experience-based discussions of what he's gone through. He'll touch base on the legal basis of REAC and some legal cases that he's been involved in involving REAC. I think you'll find that very interesting. Basically, there are two types of appeal that you can do in REAC. One is called a technical review. The other is called a database adjustment. The process for doing those appeals, both types of appeals, are the same. The primary difference, and I'll get into the details momentarily, the primary difference is that a database adjustment must be submitted within 45 days of the day the inspection report is made available for download. That's not the day you received the report. It's not the day of the inspection. It's the date that HUD made it available to you for download, 45 days. Technical review must be done within 30 days of that date. Now, there is an exception to that, and that is if for whatever reason, technical glitches or otherwise, you're unable to download the report. In those cases, and this is an unwritten rule, but we've used it successfully a number of times, if you're unable to download the report at all, the clock really would start with the date that you contacted your local HUD office and got their assistance in getting the report. And as long as you can document that, REAC will honor that as far as the deadline goes. Other than that, the deadlines are strictly adhered to. So it really is important that you remember technical reviews, if you're going to do one, must be submitted within 30 days of that date the report is available. Database adjustment, 45 days. Now, what's the difference between the two? What is a technical review as compared to a database adjustment? Well, a technical review consists of any one of three different types of issues, all of them involving material errors by the inspector. That's the language that REAC uses. That would include an inspection that included the wrong building, or a building that is not part of the property. It would include a report where the total number of units shown in the report is incorrect. Now, why is that important, you might ask? The reason why the total number of units is important is because, as you know, REAC generates a sample of units that are going to be inspected as part of the inspection process. That randomly selected sample is directly related to the total number of units in the property, and also the number of units in a multi-building property, the number of units in each building. So if that unit count is incorrect, the sampling may be incorrect, and therefore the report is suspect. And the third and most important type of technical review would be based on a non-existent deficiency. Now, a non-existing deficiency is not something which you have fixed since the REAC inspection. It's also not something that you fixed while the REAC inspector was there. It's something that did not exist at the time the REAC inspector was there. It's where he made a mistake. For example, if the REAC inspector says that your window is fogged and the seal is bad, but you know that it's just dirt, that would be a technical review because the deficiency cited by the inspector does not exist. So that's what a technical review is. And most appeals in our experience are technical reviews. And most technical reviews, virtually all of them in our experience, are based on non-existent deficiencies. And again, that's a 30-day clock. So it's real important that when you get a REAC inspection, you start watching the HUD website, the secure systems, and get that report downloaded as fast as possible so you can review it for possible appealable items. Database adjustment. What's a database adjustment? Well, database adjustment is a situation where the inspector made an error or where the inspection is incorrect due to circumstances that are not actually reflected in the REAC protocol. What that would include would be conditions that are permitted by local code. And in our experience, that's the single most usual, most frequent form of database adjustment that we do. What would a condition that's permitted by local code consist of? What would be an example of that? Well, probably the most common one we see is an air conditioner in a bedroom that has one room, one window, and you're cited for blocked egress. But the local code allows that air conditioner to be in that bedroom. REAC is going to cite you for that for blocked egress. They're required to. So don't even bother to fight with the REAC inspector. He has to make that notation. And the reason he has to make that notation is the REAC inspectors are specifically instructed not to get involved in code issues. They're supposed to report what they see. And if you have one window in a bedroom and there's only one door being the means of egress, and you're on the first, second, or third floor, or you're higher and there's a fire escape outside that window, and there's an air conditioner there, you're going to get cited for it. But usually, that condition is permitted by local code. Your local architect, your architect can tell you that. The local code enforcement people can tell you that. That would be a database adjustment, and REAC will recognize it. The second item that a database adjustment would consist of would be items that were captured and scored but are not owned or maintained by the owner of the property. For example, mailboxes, a retaining wall that's on the border of your property but really belongs to the guy next door, a fence that's on the border of the property but it's not your fence, it's the guy next door. The third type of database adjustment would be an act of God, an act of nature. Severe weather conditions, for example, caused the problem. Construction next door, they did blasting next door, and that resulted in a crack in your foundation 2 weeks before the REAC inspection. That would be a database adjustment. Now, circumstances not under your control as owners does not include one very common thing, and that's tenant-caused damage. You're stuck with that one, folks, with some exceptions, which we can get to a little bit later. So that's the two primary types of appeal: technical reviews, database adjustments. There is a third type of appeal, which is not written down. It's very informal, but it does exist. But you have to be very cautious using it. And that is when there's a breach of the protocol by the REAC inspector. Now, I'll give you an example of that. We did an appeal a while ago of an inspection. We were not on the inspection. We didn't do a pre-REAC inspection. We weren't on the inspection itself, but we were called in to do the appeal. And it turned out that one of the major items in the appeal was an electric box that was cited for exposed wires. Now, this electric box was in a common area, and as you know, that's a lot of points. Well, what actually happened? Well, the box was secured lightly by a screw, and it was lightly secured. And the REAC inspector did as all REAC inspectors do. He stuck his hand under it and gave a little, one of these things, didn't move. Now, the normal REAC inspector would say, okay, fine, it's locked, no problem. This REAC inspector pushed a little harder. Still didn't open. He then took both hands and pulled like this, ripping the cover off, exposing wires. He then cited them for exposed wires. That's a breach of protocol. That same inspector, on another project, in that same inspection, went to an apartment which was vacant. Well, not vacant, it was not occupied at the moment, the tenant was not there. Knocked on the door, no one answered, of course. The owner happened to have the key. Opened the door, the chain was on. Now, I don't know how the guy got the chain on when he wasn't there, but I'm told that that is possible with some kind of chains. In any event, the inspector said, open the door anyway, push it open. Now, the owner, for whatever reason, agreed to do that. Shoved it open, and immediately got cited for a damaged door. We appealed on that basis based on breach of protocol, and REAC did reverse that inspection. They knocked it out. So keep in mind that if there's really compelling reason, compelling argument, it's got to be significant, it's got to be really serious, and it has to be somehow provable and demonstrable. That's an avenue you can use. And basically the way you do that appeal, as opposed to a technical review or a database adjustment, is by letter. You write a letter to REAC and say, this is what happened, and this is unacceptable. Now, there's one other difference that's significant between a database adjustment and a technical review. And that is that a database adjustment, which remember includes conditions permitted by local code and includes adverse conditions caused by a third party that's not under your control. What you can do is do a pre-appeal, a pre-database adjustment request. You can go to REAC before the inspection takes place and in effect file an appeal. Ask them to recognize it as a database adjustment. There's a very real reason why that's a good idea to do that if it's possible and if it's applicable to you. And that is because the 45-day rule does not apply. So if for whatever reason REAC takes 30, 35 days to review your thing, kicks it back with a rejection, but the rejection was flawed, you don't have to worry about the 45-day cap. You can go and you have plenty of time to go back and reappeal it and pursue it with them. So that's a technique that you might want to keep in mind for certain circumstances. Now, I told you that REAC is very, very conscious of the time frames. I've seen them reject technical reviews on that were submitted on the 31st day. So you really have to pay attention to those appeal dates. So the question becomes, when do you do an appeal? Do you do an appeal on everything? There are some that argue that you should appeal every single time, that you disagree with a REAC finding. And as a consultant that partially makes his living by doing appeals, I kind of like that argument, because it's good for my bank account. But the reality is that's really not a smart thing to do. It's not a necessary thing to do. What we tell our clients is that you should do an appeal if it's going to change your administrative situation. Now, what does that mean? Well, if you get below 30 or below in a REAC inspection, you're dead meat. You're going to get called in by the HUD field office, you're going to be in real trouble. 30 is a point that you don't want to be below. So if you can go from a 29 to a 31, that changes your administrative position. So you're going to want to do that. 60 is the next cap, is the next line. 60 is passing. Now, some will say that a 61 is not a great score, but it is a passing score. So if you got in the 50s, or even the 40s or 30s, but there's so many items that are appealable, that you can get yourself up to a 60 or a 61, you certainly would want to appeal. The next administrative level is an 80, 80 or above. Normally you get a REAC inspection once a year. If you hit 80, you get a year off. It's 2 years is the period. Third cutoff point is a 90. If you can get up to a 90, that raises the spread between REAC inspections to 3 years. Clearly well worth pursuing an appeal. But again, if you're not going to make that point spread, make that change in administrative capacity, other than satisfying your ego and helping the bank accounts of people like me, it really isn't worth doing, and we don't recommend it. Now, when you do look at the points, you have to count them very carefully, because just because an item was wrongly cited or is appealable, and you can get the points back, that return of the points in many cases is theoretical only. You're not really going to get the points back. Why do I say that? Let's use the example of a unit. And let's say that the total number of points attributable to units in your property is 2.2 points. Let's say that you lost the equivalent of 2.5 points in that unit. There were so many things wrong in the unit that it totaled 2.5 points. REAC only took off 2.2 points. What that means is if you're going to do an appeal of some of the items in that unit, there's 0.3 points, 0.3 of a point in this example, that have to be recaptured before you start to get anything back. Does everyone follow the math that I'm using here? Okay. So you want to count those points and make sure you're actually going to get points back. That holds true in all of the areas. The site, the common areas, the building exterior. You want to see whether you lost more points than are attributable to that area. If you did, you're going to have to count your points real carefully to make sure that doing an appeal is actually going to get you anything back. Because you will not always get them back. Now, how do you do an appeal? Well, the easiest way is to use a form that REAC puts out. And Bill and I put together a CD, which you're welcome to have. The form is on this CD. The CD has a bunch of documents that Bill and I thought might be of interest to you. I will say one of the articles that's in this, one of the documents that's in this, and I screwed up on this. It's in WordPerfect format, and I know nobody except me in this world still uses WordPerfect. Me. And Bill. So I printed that one out for you. So I apologize. But by all means, take one of these before you leave. When you do an appeal, and this form, which is not mandatory, will point you in the direction of doing all of these things, you want to include certain things. You want to make sure you include the inspection number. What's the inspection number of the report? You want to put in the project identifying number, project identification number. That's not the FHA project number if you're an insured project. That's not your Section 8 number. That's that number that HUD uses in, I think it's in REMS, the 8000 and then 5 or 6 numbers after that. So that number has to be there. Then, separately for each and every item that you're appealing, you want to include what's the inspectable area. Units, common area, building exterior, site, etc. What's the building number? Even if it's a one-building project, put building 1. And you want to make sure that your building numbers correlate to what REAC called the building numbers. I've seen many cases where you have a 5-building project and you go left to right, building 1, building 2, building 3, building 4, building 5, but REAC, for whatever reason, did building 1, 2, 3, 4, 5. They did the opposite. Use REAC's count. Because what is extremely critical is that when you do an appeal, everything you're appealing be immediately identifiable by the REAC staffer who's reviewing your appeal, so he can correlate it with the report itself, so he knows exactly what it is you're appealing. You'll put the apartment if applicable. If it's in the unit, if it's one of the units, make sure you put the apartment number. And again, use the apartment number designation exactly as REAC did. So for example, if you call the unit 101, but REAC calls it, because it's in building 2, 2-101, you call it 2-101. You want to correlate it with REAC. Then you put the basis for your appeal. Why are you appealing it? Well, if it's an air-conditioner situation with blocked egress, it's because the code allows it. That's your reason. And you want to specify that. And then you want to give documentation, and the documentation is the key to the whole thing. In many cases, you're going to want to take photographs. In other cases, you're going to want to have documentation that's written. Now, the preferable, indeed almost always the only acceptable form of documentation, is third-party experts. REAC, and this is something which some of us have been arguing for years, doesn't really like testimony by tenants or project staff, because you can be forced to say something that you don't mean. At least that's the theory. You want to use third-party evidence. So, for that air conditioner that's in the window, you would want to have either your architect, and make sure his license number is on his letterhead, or at least in the signature, he's got to be licensed. Or you want to use the local, if it's a small city or a small town, you might be able to get the local fire marshal, local code inspector to come in and write something that says, I saw it. It's got to be very specific, the documentation. It has to, like I said before, tie in with the finding. I went to unit such and such on such and such a date. I saw the air conditioner that was cited by the REAC inspector. That air conditioner is properly installed and meets all applicable codes. That kind of documentation is needed for each and every item you appeal. You want to make sure you have it. What do you do with the appeal once you have it? Well, you package it so it makes it in a sensible format, and you're going to send it to REAC in Washington. And the address you're going to send, get your pens out, the address that you're going to send it to is the U.S. Department of HUD, Attention Technical Assistance Center, /, if it's a technical review, /TR, if it's a database adjustment, /DBA. The address is not HUD's normal address. The address is 550 12th Street Southwest, Suite 100, Washington 20410. Now, it's not required, but I would also send a copy, a complete copy of the appeal to your local field office. Now, why do you do that? Local field office has absolutely nothing to do with the appeal. All they get to do is see the results of your appeal. Then the REAC is not going to call the field office is not going to do anything with it. But your real audience, in my mind, is the local field office. They're the ones you want to show that you're really doing a proper job. They're the ones you want to demonstrate to that you are properly responding to the REAC inspection, and that if this is the case, that REAC was just wrong and that score does not reflect what you should have gotten. So we strongly recommend that a copy be sent to the local field office. Additionally, if the project failed, if you got below a 60, I wouldn't wait for the field office to call you. I would call the field office. And the reason I would do that is because you want to make sure, especially you have good reason for this, you want to make sure that sanctions are not going to be imposed on you. If you failed and you got a 55, and it was because of one sprinkler head that was bad, or one electrical outlet that was, one knockout that was missing in an electrical box that was buried behind 4 locked doors somewhere.
Exactly.
That does not mean your project is a bad project. You want to make sure the field office understands that. So I would be proactive and I would call them. So, to review, what is the process for doing an appeal? It's really more than just filing those documents. An appeal really starts with your pre-REAC inspection. You want to make sure when you do your pre-inspection of the property, and by all means you want to do a pre-inspection of the property, whether it's by someone like my group, or whether it's someone in your own organization, or whether it's someone else, another third party. You want to make sure that someone who's familiar with the REAC protocol, the entire protocol, does that pre-inspection. Because part of that pre-inspection is not only to identify issues that have to be repaired or fixed, it's to identify issues that for whatever reason cannot be fixed, but which you're going to appeal if they're cited. And you want to start getting set up to do the appeal. Now, a great example of that would be what's called the work-in-progress appeal. Work-in-progress appeals relate to appealing an item where the REAC inspector was correct, problem exists, but hasn't been fixed yet. Hasn't been fixed yet because you're under contract to get the work done, and for whatever reason the work hasn't been done as yet. Now I have to caution you that the work-in-progress definition from a practical standpoint is bouncing all over the place within REAC. If you read the written guidance, a work-in-progress appeal can only be done if you're dealing with a major rehab of the property, a major plan of action that HUD has sanctioned, and the work has already been initiated. That's what the written guidance says. As a practical matter, REAC has gone all over the place. They have gone as leniently as times as to giving us back points because a window was cracked and we got a letter from a glazier that says I was put under contract 3 days before the inspection and I just haven't been able to get to replace the window yet, and we've gotten the points back. We've also had appeals like that rejected on the grounds that it's not a full plan of action. But my point is, when you're doing your pre-inspection, you want to identify situations like that. You might even want to do a pre-inspection database adjustment for that fence, that broken fence that really doesn't belong to you, but belongs to the guy next door. You might want to file a proactive database adjustment just to make sure that it doesn't become an issue later. Because if you can avoid doing an appeal, you save time, you save money, you save effort, you save aggravation. And that's part of the pre-inspection protocol. The second part of doing the appeal is during the inspection itself. You want to make sure that someone who really knows the protocol is on that inspection. The word a lot of us use is shadowing the REAC inspector. But you want to watch that inspector, make sure that he's following protocol, he or she is following protocol. You want to make sure that if there is an issue that is appealable, that is something that where a photograph would help demonstrate the issue, you want to take a photograph of that. Now some people take photographs of every single item. We don't. We take photographs when we do shadowing of those items which we think we might want to appeal or otherwise have issues with. The photograph should, by the way, be taken with a camera where you can date and time stamp. REAC prefers that. Now I know obviously you can change the date on a camera any time, so the date stamp really doesn't mean anything, but REAC does want that, so they prefer it. The other reason why you want to make sure someone is there is because there is one issue where you might want to appeal, but you're not allowed to appeal, and that is the level of a finding. As you know, there are 3 levels: level 1, level 2, level 3. Level 3 being the most severe, and typically a level 3 is the thing which you're most concerned about, because as I recall, the point deduction for a level 3 is 4 times the point deduction for a level 1. So you want to really watch out for those. Now you can't appeal, technically at least, you're not supposed to appeal the levels when you do a formal appeal. So when can you address levels? During the REAC inspection itself. If the inspector calls out something as a level 3 and you know it to be a level 1 or 2, you're going to want to say something. So you want to make sure someone who's knowledgeable is there, who's able to say something. Now, I will caution you that part of the REAC protocol says that if you become argumentative, the REAC inspector no longer has to call things out. So you don't want to start fighting with the REAC inspector. You don't want to start arguing with him. If he disagrees with you, document it and be done with it. Don't get into a fight with the inspector. But that's the other thing. Then finally, and this is just a little bit of a recap, once you get the report, check it for the points to make sure, to see whether or not you can actually recapture something. Make sure that it's going to bring you to a different administrative level. And then follow that format which I gave you. Be very specific, connect all the dots, make sure your documentation is solid, and make sure you get it in on time, because REAC has been enforcing those deadlines. And I'm now going to turn it over to Bill, and then after this we'll have a short question and answer period.
Thank you, Dave. Mr. Carlson, Mr. Cushing, members of the audience, thank you for inviting me here. I should probably just say what he said. I have used Dave's services. I got a 91 because I'm a lawyer and a little nuts. I still want to appeal, but smarter people have talked me down from that perch, so I'm not appealing my 91. But I'm still angry about it. Are there any lawyers here? Oh, you don't count. I don't want to give too much of a legal lecture because, first of all, I don't have a license in the state of New York, so anything that I say here, this is based on my New Jersey license and the fact that I do this stuff with HUD and send it to Washington, but I can't give legal advice in New York, and I don't want to give anybody any legal advice today because this is pretty general. I should start by saying that any objective person looking at the REAC regulations, looking at the REAC process and the appeal process, would say it's profoundly unfair, wrong-headed, and primarily un-American. The only thing that really saves it, and this was pointed out to me by Leroy Clark, my criminal procedure professor back in 1973, is that they're usually right. So before I go off on people who I think are wrong-headed and misdirected and bureaucratic, the fact of the matter is you will find that most of the time, most of the stuff they're saying is probably not going to be subject to appeal because they probably figured out long ago what they could get away with and what they couldn't. The appeal process goes to Washington, where it is turned over to bureaucrats with no experience whatsoever in our field. They are not confused by facts or by the law. They have none of them. They have their own self-determined ideas of right and wrong, good and bad, and you are pretty much at their mercy. But their mercy is pretty much available. If they make a mistake, they may not have what we would like to see as procedural and substantive due process protection for us, but they got a pretty good sense of what's going on in the world. So if you can get to them and you can get their attention, I have found that appeals work. When Dave said, by all means, send your appeal and make a proactive call to your rep or to the director of multifamily at your local office, by all means do that. When I've had bad scores on my clients or for myself, the director of multifamily in Newark would call me up and say, "Where is your head? Straighten this out." And I would. And that's why I ended up doing REAC appeals, because other folks who he felt were wrong, he would say, "I should talk to Eaton, he knows how to do the appeals." If there is a mistake, you have a very narrow evidentiary window that you can use, because the regulations change a fundamental aspect of Anglo-American law that goes all the way back to the Magna Carta. And that is, usually you're innocent until proven guilty, except at REAC, where the burden of proof is on the person taking the appeal. They accept as gospel whatever it was that their guy saw until you can prove him wrong. So unlike a prosecutor who has to prove that you've done something, all he's got to do is make the accusation, and you got to prove you didn't do it. This is nuts. I mean, but it is embodied in the regulations. So unless you've been so profoundly wronged that you think you're going to take your appeal through the administrative process to the federal district court, suck it up. Because if you're not in front of a judge, nobody at HUD cares that they have reversed 1,000 years of history. Nobody at HUD cares that they have made inadmissible the evidence presented by your manager, by your lawyer, by your super, by your contractor. All of this is inadmissible. It is considered non-objective. And I've looked real hard, and the only case that I can find of any significance in the history of the United States that says that somebody who has actual knowledge, has an actual interest, is actually invested in this case, and is not allowed to even testify, is Dred Scott versus Sanford in 1856. You may recall we fought a civil war over that case. So we are now essentially reduced by the federal government to the status of slaves. And that's annoying. And if it weren't for the fact that they were right most of the time, it should be reversed by the courts. But it hasn't been. It hasn't been touched. Which leads us to what is admissible. And what is admissible is testimony from a licensed professional, testimony from a fire marshal, or testimony from a construction official. Now, I'm a lawyer, but I'm also a general partner and executive director of a 100-unit senior building in Long Branch, New Jersey, the Section 8 building. Long Branch is not such a big city, and I get inspected by the fire department, and I get inspected by the construction department, and I get inspected by folks who I see at least once or twice a year. And I make it my business to know them, to know their families, to go to their golf tournaments, to spend time with them, because when I need someone to show up and stand up for me, I need these guys to do it. And God bless them, they do. In the city of New York, getting to know the construction official or the fire marshal is probably a bigger challenge for you guys. What I would recommend that you do, if you can, in your neighborhood, if there is a retired fire marshal, if there is a retired construction official, if there's someone who's had the license, who's got the time, court them, be nice to them. Get folks who've got the right kind of credentials, who will come when you call them. That 30 days goes by like that. And if you've got to rely, like I did at one point, on the Bayonne Fire Department to show up and give you an opinion, you might just as well drown yourself, because they're never going to do it. They're not going to know you. They're not going to want to sign something for the federal government. They're not going to want to get involved in a federal investigation. As far as they're concerned, this is none of their business. So if you can find someone who will make it their business, that's a plus. The easy way around that, frankly, is hire somebody like Dave, who will go through and do the pre-inspection, who will have a record for you, so that when you have to file an appeal, you've got someone who they know, who has a record, who can testify, and who is independent. He may be under your contract, but he's an independent enough guy so that they will take his word, or somebody like his word, for it. But they're very, and I'll get to it later, they're very, very tight on what they're going to accept as testimony. I have, on appeal, a somewhat more expansive view than Dave does about what you appeal. If there is any excuse to appeal something, no matter how remote, I appeal it. The reason that I do that is, again, if it looks like your appeal is not going to be successful and you're going to have a problem with a Section 8 contract or Section 8 renewal or a bank or, in my case, New Jersey's Housing and Mortgage Finance Agency, if you're going to have to go to court, you better have said everything you want to say at the administrative level, or you will not preserve your rights to go to court on it. And if you want to take this kind of a case to court, and there are a couple of people who have, you need to have every single bullet you can put in that gun. Even the duds are better than not having them. So don't give up anything at the appeal level. They can always say no. They can say no anyway. But if they've gone way too far over the edge, at least then you got a little bit more ammunition if you go to court. If you're appealing on 2 or 3 little dinky things, the federal district court will have no trouble at all saying the Department of Housing and Urban Development is the expert on this. We accept what they said, get out of here. If there's 40, they might pay a little bit better attention. I'd also say, and again, just for record preservation purposes, we know what they consider to be incompetent testimony. Use it anyway. Preserve it for the record. If your manager knows something was wrong and they say, well, we don't believe the manager, put it in a certification anyway. Have him certified of the truth of what he's saying. It doesn't matter if they like it or not. A federal district court will pay a lot more attention to the manager than REAC will. REAC considers them in conflict of interest. No one else in the world considers them in conflict of interest. If they're willing to lie, there are punishments for lying. If they're willing to interfere in a federal investigation, probably nobody here has heard of Sarah Boast, but she was the mayor of Irvington. She spent 18 months as Martha Stewart's roommate down in West Virginia because she interfered in a federal investigation. They will accept your word, because if you lie, you're in trouble. I would go a step further also if you are facing a contract cancellation or foreclosure. I would challenge the fundamental constitutionality of the regulations in disallowing testimony and changing the burden of proof. I don't think that's been successful. I've never had to go to court with it, but if I did, that's one of the things that I would do. I think regardless of whether they advertised it and adopted it and have the expertise, I think when you reverse our history like that, somebody's got to challenge it. I'd already said that it's crazy if you've got a 91 to take an appeal on principle. In my case, I should have probably a 94, but 2 weeks before my inspection, I changed all the wall plates in my common corridors because I just want to make sure. One of my tenants apparently liked the new wall plates enough, so he replaced one with his own cracked wall plate, which cost me 2 points. And my manager and my consultant and my lawyer have all talked me down from taking that appeal. But the real reason I wanted to take the appeal, which is really probably humiliating, and I shouldn't even consider it, is that what I really wanted to do was find the guy who took it and then serve him with a cease and desist and an eviction notice for $1.98 theft, and have him write the appeal to REAC and say, I'm going to have to spend the winter living under the boardwalk because I'm going to get evicted because I cost my landlord 2 points on a REAC. And I'd like you to reverse the 2 points so that I don't have to live rough this winter. And everybody said, yeah, good luck with that. So I've climbed down from that one, but I'd love to have them make the decision that they will take someone who has an interest, who's a tenant, who's under their regulations incompetent to testify, and have them put him in a position where I can put him out. Not that I would, but that I could. So anyway, we're going to leave that alone. I brought with me, and Dave has on the disc, the resources that you need to be aware of and your lawyer will need to use. Essentially got them, I'm not going to go through what they are, but there is a full set of regulations at I think it's 24 CFR section 200.850, and that's where you find the rules, and your lawyer's going to have to know them. There is an independent set of technical review and database instructions. I find that anytime HUD feels they want to put something in writing, they very rarely read their own regulations and they very rarely understand what it is that they're about. So they do inconsistent things. I can't even tell you what the inconsistency is until you have the appeal. But look at the instructions, because probably somebody violated the instructions. There is what's called the REAC compilation bulletin. The latest one is Rapid 4.0 version 1. All of your violations are supposed to be listed in here. Sometimes, and in my experience, at least one time, the inspectors aren't up to date on what the rules are. And they'll use either an old rule or an old notice because they haven't gone to the time and trouble to update themselves. And that's the kind of thing that will win. If you can show that they used a regulation or a standard that is no longer in effect, because every time one of these comes out, it supersedes everything before it. So if they're relying on something that came before, and I've had real good success with that, I had to go to Washington to get it, but I sat down with the director of REAC, I asked her where the problem was, I showed her where the old notice was, and then I showed her the new compilation bulletin that overrode it, and she said, you know, you're right. And I got a reversal. There is a checklist, it's in the package. There are, as Dave pointed out, appeal forms. I use the appeal forms to abbreviate what's in my brief. When I do an appeal, I do it just like an appellate brief. I have a statement of facts, I have all of the issues that are on appeal, then I have a statement of what the law is, and I submit it that way. But I use their form so that they've got a checkoff list so that they know what it is, and also so they can't say to me, gee, we'd really prefer you use the form, please resubmit the whole thing, which they're perfectly capable of doing. And there is relatively new, August 9th, 2012, big fat scoring regulations. There's a lot of detail in the regulations. Again, your lawyer's going to look at this. I think you're better off with a consultant like Dave knowing it than you having to learn it. It's a lot. But the folks who do it, they know their way around it. I'm going to give you a couple of examples of appeals that were unsuccessful and why. The successful ones you'll figure out, but the unsuccessful ones are the ones where you see where they see the holes. Here the deficiency was site, grounds, overgrown, penetrating vegetation. They said written statement by plaintiff's attorney citing OD is simply false. Inspector should be required to provide place and nature of cited deficiency. Certification of Hubert Graham, manager Clinton Hill, stating there is no overgrown or penetrating vegetation anywhere in the site. So we gave them photos of the whole site and said, we don't know what you're talking about. This is their answer. Documentation proved inconclusive or could not be objectively verified. Referencing your statement concerning the inability to locate the location for recorded deficiencies. Inspectors must be accompanied by project staff while performing REAC inspections, and it behooves project staff to take notes of observed deficiencies. Level 3 deficiencies per protocol are the only deficiencies that contain comments and location. Also, written statements provided by personnel associated with the property are not considered objective documentation to corroborate the inspector's errors. So, showed them pictures, said this didn't happen. They said, yeah, but that's you telling us it didn't happen. Our inspector said it did, so you lose. Next one is Site storm drainage, damage obstructed. Written statement by plaintiff's attorney cited OD is simply false. Inspector should be required to provide place in nature cited deficiency. Manager said there is no evidence of damage or obstructed storm drainage. Documentation proved inconclusive or could not be objectively verified. So, inconclusive. Written statement provided by personnel associated with the property are not considered objective. Referencing your statement concerning the inability to locate the location, inspectors must be accompanied by REAC staff, by project staff. So if you can't figure out where it is, we're not going to tell you. This one had to do with concrete work. Written statements such as certification of Dwight Angeles, owner Dwight Angeles Painting and Carpentry, stated, I am an independent contractor retained by Clinton Hill Gardens to maintain and repair concrete work on the properties identified in the inspection report, blah, blah, blah. Lacked appropriate licensed accreditation, including words related to concrete work, in the New Jersey Certificate of Formation, line 4, item 4, which said, home improvement and painting, decorating, commercial and residential, to substantiate the claim all concrete work is wearing and weathering normally. In other words, because he didn't have a certificate of incorporation and he did concrete work, he's not allowed to talk about concrete work. Also, a written statement provided by personnel associated with the property are not considered objective documentation. Then the same thing about inability to locate it. This one I love. There was no documentation submitted that there was no paint cracking, flaking, or otherwise deteriorated on the building exterior surface. We gave them pictures of the building exterior surface, but they thought maybe there's more surface there that we didn't give them pictures of. So since there was no picture that didn't show there was no flaking somewhere, we're in the position of not having proved the negative, so we're guilty. One of the things that we won on was the neighbor fence. And that's because the neighbor's fence was owned by a church. And even though the fence was messy and tilting and we knew there was a problem with it, we also knew the pastor. And he wrote a letter that said, that's my fence and I know I got to repair it, but frankly I'm waiting for the congregation to raise the money. They gave us the fence. And the fence is one of those things that you can do ahead of time. And one of the things you can do if you don't have a cooperating pastor or a cooperating neighbor is send them a couple of certified letters saying, I'm going to be in trouble with the United States of America if your fence isn't fixed. Please fix it. They can blow you off all they want to. At least you now have some kind of written record that says, A, the fence isn't mine, B, I can prove that, which you can because you've got a copy of the tax map, and C, I've done everything that I can. They gave us that on the fence. I'm open to questions as long as you aren't asking legal advice. I suppose I should do one other thing before I do that. Let me talk just briefly like a lawyer. There are some cases, not on REAC, but that deal with HUD, that have some useful language in them. And when you've been rolled over by HUD, which I have on other than REAC things, it's good to know that HUD doesn't always get away with what it wants to get away with. One of them is Committee for Fairness versus Kemp. And this deals with a HUD attempt to change the basis for evaluating a public housing authority budget. And it said, a precise and mathematical formula for which the PHA were required to use and which contradicted existing regulations. Agency actions which established new methods for determining the obligations of the regulated parties and the distribution of funds are subject to notice and comment rulemaking. As for retroactive application of administrative rules, they are not favored, and a statutory grant of legislative rulemaking authority will generally not be understood to encompass the power to promulgate retroactive rules. In other words, if they've come in with something that changes what was previously allowed. It's got to be done by notice, it's got to be done by comment, and they can't retroactively apply it. And if they do, this was a decision of the Federal District Court in D.C., which is a respected court, and you can at least make an argument to a federal judge that under the Constitution, where we have a prohibition of ex post facto laws, this is effectively an ex post facto law. They're making a law after you've done something, and they've effectively criminalized it or made it an administrative issue that wasn't before. Another case is Patriot versus the U.S. Department of HUD, which says, apparently HUD has not learned the lessons of Housing Study Group versus Kemp, but the court will instruct it again. HUD is not free to ignore requirements of the Administrative Procedure Act in its haste to address perceived problems in the realm of national housing policy, whether it be massive defaults by co-insuring lenders or fees charged for assistance in obtaining reverse mortgages. Finally, the public interest is best served by having federal agencies comply with the requirements of federal law, particularly the notice and comment requirements of the Administrative Procedure Act and the agency's own stated policies. They're not supposed to violate their own law. They do, but they're not supposed to violate their own laws. And when you catch them, the courts are sympathetic. Well, this is one that I particularly like. When you appeal to REAC, you go to their technical review division. That means the people who are writing the rules and the people who are investigating under the rules and the people who are reviewing the rules and the people who are reviewing the facts and the people who are making the decision on your appeal are all the same people. You know, it's like, yeah, we'll make the rules, then we'll send somebody out to see if you violated them, we'll decide whether you violated them, and then we'll tell you whether or not you violated them. This is from Gutierrez de Martinez versus Lomango, United States Supreme Court. The argument for unreviewability in such an instance runs up against a mainstay of our system of government. Madison spoke precisely to this point. No man is allowed to be a judge in his own cause, because his interest would certainly bias his judgment and not improbably corrupt his integrity. With equal and a greater reason, a body of men are unfit to be both judges and parties at the same time. That's from the Federalist number 10. In re Murchison, Supreme Court case from 1955, our system of law has always endeavored to prevent even the possibility of unfairness. To this end, no man can be a judge in his own case, and no man is permitted to try cases where he has an interest in the outcome. Sound familiar? The last one, this is the New Jersey Supreme Court, because this is where I practice and I like the New Jersey Supreme Court. This is W.E. Pangborn and Company versus the New Jersey Department of Transportation. Moreover, we have insisted that in the exercise of statutory responsibilities, the government must turn square corners rather than exploit litigational or bargaining advantages that might otherwise be available to private citizens. The government's primary obligation is to comport itself with compunction and integrity, and in so doing, government may have to forego the freedom of action that private citizens may employ in dealing with one another. We have similarly insisted that government adhere to strict standards in its contractual dealings. I think it's good to point that out to the government when you file an appeal. They're supposed to be fair, reasonable, and impartial, and we expect that. Thank you.
I told you he has an interesting take on things. Okay, any questions, comments, thoughts? Greg?
Question, now that REAC is starting to experiment with taking pictures as part of the REAC program, do you think that may have an effect on the appeals process?
Well, for those who don't know it, REAC right now is experimenting with taking photographs of level 3 and only level 3 findings. Several of the quality assurance inspectors are using it, and I understand a couple of inspectors are doing it also. The implementation of this is about 6 months behind schedule. My understanding now is that they're going to require it on a wholesale basis sometime in January. The stated, or at least my understanding of the reason why they are going to be taking the photographs is related to what Greg was saying. It's to forestall appeals. It's to stop appeals from taking place when appeals are inappropriate. I suppose it's going to have some impact on that. I think the first question to ask, though, is just how workable the photographs are going to be. How good are the cameras? How good is the camera angle? How good is the lighting? What do you do with a building facade if the problem is building exterior? Do you step back a block, half a block away from the building and take a picture of the entire building and then use Photoshop to circle the problems? Do you take 47 pictures of one picture of each spalling brick? I really don't know. A lot of deficiencies are not really amenable to photographs. A lot of items are self-explanatory. I mean, an air conditioner in a window is an air conditioner in a window. I mean, why do you need a photograph of it? It's there. Unless, and I've not heard of this, there are people who are filing appeals based on the concept that, what air conditioner? There was no air conditioner there. I haven't heard of anybody just outright lying in appeals. I've heard of people using creative arguments, but I've not heard of people actually lying about it. So,
I just add to that when you're dealing with the government, you're dealing with an enormously powerful adversary. And many of the people who go to work for the government right out of college. And they see themselves as the defenders of right and truth against an otherwise unruly population. And as I said, probably most of the time they're right, but there is a large number of lawyers who do defense work. And we would love to see photographs that their guy took. Because the more evidence you give us, the more questions we got. The more stuff they put out there, the better off we are. And if they can weed out some of the junk, hallelujah, because their guys are like the police. Most of the time, the police are right. If they weren't, there would be an open rebellion here. And when they're not, there is an open rebellion. Try Ferguson. But most of the time, they're right. But when they're wrong, they're so dumb. And it's such an opportunity for people who defense work to get more evidence, not less. My suspicion is you'll take the pictures, you won't get to see them. You may get to see some of them, but you'll have to go to court to see all of them, because they'll deep six the ones they don't like. But it's okay. Gives you another item of appeal. We saw the guy take 6 pictures of the facade. How come we only got 1 picture? Where are the other 5? What did they I mean, give me 2 minutes, I'll give you 20 minutes worth of questions. The more evidence there is, the more opportunity there is.
the goal, by the way, is, at least the stated goal, is to take photographs of every deficiency regardless of level. I should clarify one thing that Bill mentioned. He was referring to the compilation bulletin and the fact that there have been several iterations of it, and the most recent one is on the disk. That compilation bulletin is not the only source of documentation that you're going to want to look at. The compilation bulletin serves as interpretation and clarification of the definitions dictionary, a copy of which is also on the disk. The dictionary is about 300 and some odd pages, 1 page per deficiency. Most deficiencies have got 3 different levels. So you don't want to try to memorize the darn thing, you just want to be aware of what's in it. And it's a good idea when you're on a REAC inspection to bring a copy of the compilation bulletin, to bring a copy of the dictionary. I know we keep it on an iPad so we can search very quickly. Because, as I indicated earlier, when you're part of shadowing a REAC inspector is setting yourself up for appeal or precluding appeals. If the REAC inspector is making a mistake or is using something that is obsolete, as Bill suggested, can and does happen, if you have the more up-to-date document with you, you can show it to the inspector. He may or not buy into it, but he may not. I'll tell you an interesting story. One appeal we have going now for one of our clients, and it hasn't yet been decided. I'm waiting. I'm very curious to see how this one goes. Are you all familiar with the definitions on screens? You know that the way it always worked is if you don't get cited for a missing screen or a damaged screen until and unless there are a total of 3 that are found. Well, guess what? That's not the definition anymore. No. The definition has always been, and the only written definition you'll find is if they find 3 damaged or missing screens in the course of the inspection, you will get cited. 2, nothing happens. Well, I was on an inspection with a quality assurance guy, actually, about a month ago. And he walked into a unit, and in that unit, that window had a screen, that window had a screen. That was a different type of window, no screen, no problem. That window was the same as the 2 that had screens. There was no screen there. He cited them for a missing screen. So I pulled up the documentation and, hey, how come you're doing this? Turns out that the new software the inspectors are using changed the definition of screens. So we have an appeal going now. I mean, we're doing the appeal because there are enough other items to make it worth appealing. I mean, that screen was worth maybe 1/10 of 1 point. But we did include it. Since we were doing an appeal, we may as well include everything. The basis of our appeal is that REAC changed the definition without notifying the public. And the quality assurance inspector I was with acknowledged that it has not been put out anywhere, no memos, nothing posted on the web, nothing on the Q&A page of REAC. It's nowhere except in the software. So we're waiting to see whether or not how REAC responds to that particular appeal. I think it's going to say a lot about how they respond to things generally. If I were still at HUD, I would argue that the response that HUD should make is, we're giving you back your points, and we're publishing something so that the world knows that the change has been made. Because that's the fair way to do things. We have found, I should say, that the initial reviews of appeals, which are by technicians, have improved a lot, but there still are problems with it. Sometimes it is necessary to go beyond them and contact the REAC hierarchy directly. And if there's a grievous error by the technician in reviewing the appeal, that can sometimes work. There's no documentation on how you're supposed to go about such a letter, but we've done it a number of times. I'm sure Bill has done it himself when he handles appeals. So it's something to keep in mind. But my point is, you want to be aware of the most recent stuff when you're on the REAC inspection and when you're preparing your appeal. And that would be the compilation bulletin, and only use the most recent one. The definitions dictionary, and again, there are 2 versions of that. You want to make sure you're using the most recent one. It's on the CD. And there's also a wide assortment of other interpretive documents that are out there. There's question and answer pages where REAC responds to things. I mean, it's kind of unofficial and informal, but these are things that folks like us use in trying to determine what is and is not an appealable item. Comments, questions? Yes?
Hi, David.
Yeah, hi, Will.
Yeah, I have a couple questions.
Sure.
One's a couple of simple ones. One is, if you have both things for a technical and a database adjustment appeal, do you do 2 appeals?
Well, what we do is we use the form, and one of the lines on the form on the upper left is type of appeal, technical review, a database adjustment. We'll do a separate form for each.
Okay, you can use the 30 days for the one, or do you tend
Well,
to send it at the same
we try
time?
to do everything within the 30
Get it
days.
into the 30 days.
We try to get everything in within 30 days. Because once you're dealing with it, you
Yeah.
want to deal with it.
Okay, that makes sense.
But we do a separate document for each, but it's combined.
I understand. I thought it was a good idea to send something to the field office. Do you recommend sending it here in New York to Teresa or?
We address it to Teresa, and I imagine that it winds up with Jenny.
Yes. Yeah, okay.
Yeah, for those who don't know, Jenny Ramos is here, and Williams is here from HUD. So be careful what you say about the New York office. They are very nice people.
I want to get an idea of what the range of REAC scores is. So it's a distribution, you know, and part of my question is if we get a, you know, you were talking about when do you make the decision to try to appeal and the administrative level and so forth. If you get a score in the 60s or 70s, is that something that HUD is going to look down upon, or is that sort of a normal score these days given some of the weights they give to deficiencies?
I haven't seen any statistics on it. I understand that scores have been increasing generally. That the average scores are a lot higher than the 60s or 70s. I think most HUD field offices recognize that 60 is a passing score, and they will tell you that if you're in the 60s, that's really not all that good, and they would like to see you and they expect you to do better than that. I'm told by people within REAC that the average scores are way up there, that most people do pass, by far the majority. Jenny, do you have a sense of that?
Well, here in New York, I agree. You know, scores have been better. They are getting better. They, you know, on average, properties are scoring a lot higher. And as you indicated, a 60 is a passing score, but we don't consider it a good score. So in most cases, properties that score below 60, as you indicated, we call them in, as well as property that score within the 60, you know, score range. We tend to call them in as well to see whether or not, you know, there are any issues going on in the property that can result in a failing score in the future, or in fact you're in the process of making repairs and that's the reason why you score low. But as you, I mean, we've had properties scoring from anywhere from a 2 to 100. And you're within that range. Now, below 30s, I have to say, unlike, you know, when REAC first came into play, we used to get a lot more below 30s than we actually do today. You don't, it's not a common thing these days for property to score below 30. Within the 60 to in the 90s, I would say, as REAC progresses, we're seeing higher and higher scores.
Do you, you know, one of the things I have seen, you know, there's a couple of things that you can get 10 points off for, right? Electrical covers and so forth. To me, that seems too high. And I'm wondering what the rationale is for that and whether I'm alone in my feeling about that.
Well, it's a great question. You're far from being alone. I'll make 2 points. The first is that, and I don't believe we included it in the disc, but I can get a copy to you if you shoot me an email. When REAC first was established, and when it was in the process of formation, the folks in Washington, this was in, I guess, around 1996 or 97, they called in about a dozen people in the public housing world, and separately a dozen people from around the country from the FHA, insured world. And I was privileged enough to be one of those that was asked to come down to start going over definitions and all of that and help set up some of the criteria. And one of the guiding things that they were using, and this led directly to the levels and to the point spreads and how they decided, was the criticality. That's the word that they use, the criticality of an item. So an electric outlet, you can get electrocuted from that. That becomes a very significant thing. A non-functioning sprinkler. Here I think they went a little crazy because they don't use proportionality, but a sprinkler, if a sprinkler fails to operate, someone can die. At the least.
Sprinklers, you know,
Yeah.
they
Well, that's where I think there's a mistake. There's a problem because of No, I understand, I'm just giving, I'm not justifying it.
Yeah,
I mean, I was one of those that was, and continues to be, rather critical of REAC for a lot of reasons. I think it's a good faith effort, but I don't think it really does what it's
I mean, it
meant.
seems to me, it's critical, but 10 points seems too much.
I'm not disagreeing with you. Now, the other thing
So
that...
is there some movement to?
Well, there has been a little bit of movement. The movement was generated not because of the point thing, and it used to be you can lose as many as 17 points for an outlet. 17 points for a roof fan that's not working. One roof fan. You have 43 roof fans, one not working, you lost 17 points. It was amazing. The change in the scoring and the implementation of caps, and that's what the document that was in WordPerfect was, which I printed out. They put new caps on the deductions, and that was based not because of the concern that 17 points was too much. That was part of it. But the main reason was they were trying to respond to the issue of multiple buildings. Because as most of you know, if you have one building, all the points for a given area are attributable to that building. If you have two buildings, now suddenly the points are split apart. Now, they're not necessarily equally split apart. If you have two buildings that are exactly the same, and they're not touching, they're not contiguous, if the buildings are identical, the points for the common areas, building exterior, basically will be divided in half. So whereas it used to be 17 points, now all of a sudden it's 8.5 points maximum for the roof fan because each building is looked separately. That isn't necessarily true. If the buildings are not identical, the points are not split in the middle. So if you have one building and you have a separate guardhouse that counts as a building, and the guardhouse just has one thing, the building exteriors are not going to be split in half. And the system points are not going to be split in half. There'll be a couple of points pulled out of the main building and attributable to the secondary building. But they were trying to address concerns that were coming largely from New York, actually, in many cases. Because in New York and other urban areas, you have buildings, rehab brownstones, for example, that touch each other. Now, they're totally separate buildings. If they're FHA insured, the HUD 2264 is going to call them separate buildings. But REAC uses a magic word, and the magic word is contiguous. If the buildings are touching, they're considered to be one building for REAC purposes. So there was a disparity in how things were happening. So that was one of the ways in which REAC, and this is fairly recent, decided to address that is by putting new caps on the deductions. So for example, the most you can lose for a system item, such as an electrical box, is now 10 points. It used to be 17 points. So,
Just to comment on that, when you talk about scores getting better, this is very difficult for me to admit because I'm an adversary, but it's entirely possible that the system may be working. Things are getting better. That the reason they put it in to protect everybody's interest is actually protecting everybody's interest. Now, I'll write that down. I never argue that. But the fact of the matter is, on a practical matter, they're not always wrong. You know, it's not an insane system. It has bits of insanity like we all do. But like school systems that teach to the test, after a while, and I'm from New Jersey, if you got a bad score, you'd get a phone call. If you got 2 bad scores, then you had to go in and talk to Walter and Diane, and they would systematically dismember your manager and maybe your owner at the same time. And that was really not fun. And most of the time, because they were on the scene, they could look at a REAC and they could know what the site looked like, and you weren't going to be able to BS your way out of that one. You were in trouble. I mean, I'm a lawyer. I've been there with my clients. I've watched it happen and watched things get better, watched managers get relieved of their duties, watched things improve. Not everything, not always, but this is a system that's really pretty comprehensive, and as I said, galling it is to admit, I feel like the police, most of the time they're right.
Just out of curiosity, are there any questions from the folks on the web right now?
There is. They wanted to know how long does it take for an appeal, to get a response for an appeal.
The response time seems to have been improving. The question is
Not
what
bad.
Yeah, it used to take several months. We're now finding typically well within 6 weeks, and sometimes faster, we're getting a response. So it's pretty quick.
I can give you the dates on this one. This is a 2010. I'm sorry, I'll give you the dates. This is an August 20th appeal of 2010, and this is odd, but I guess they didn't date their answer. There's probably a cover letter that really gives them. But I think they were pretty quick. They, you know, all of this stuff is in their computer. All those answers that I read, you can see they sound a lot alike. They just push a button and that answer comes out. You know, no, you lose because blah blah blah. No, you lose because, and they're all the same. So it's not that hard for them to say no, and it's probably not that hard for them to say yes. But it's all like a macro. You know, they go through and they say, all right, this one's junk, bang, and you get the same answer.
Questions, comments? Come on, folks, this is such a interesting topic.
Well, I'll throw the electric box. The electric box is in the boiler room. The boiler room's locked. It's nicely, snugly, securely fit. This is a panel for the pump. Can you be cited if you don't have a tie wrap on it or a padlock on that box?
Yes.
Maybe.
It can be, yes.
An electric box should be secured.
What does
But if it's not
What
secured-
does secured mean?
Secured means that you can't open it without a tool. Now, obviously, if in the example I used earlier, the guy takes his hands and rips at it, but that doesn't count. Usually it's a plastic tie. Now, the thing is this. If it's not secured, the inspector opens it. Then the threshold becomes, are there any exposed wires or connections? If there are no exposed wires or connections, you're okay. Great example are timer boxes. Now we always tell, when we do a pre-inspection, we tell our clients, secure the timer box. Put a tie on it, put a little lock on it, whatever it is, because then the inspector won't open it. But before you lock it, most timer boxes come with a little cardboard insert. Put the insert in it. Because you never know, somebody may go down to the basement after you locked it and remove the tie because they had to do something with the timer and forget to re-secure it. In that case, you want to make sure when the REAC inspector opens it, and he will, that the cardboard piece is in there, the insert is in there. That means you don't have exposed wires, so you will not be cited.
What about bars on first floor windows? You have a fireproof building, you have two means of egress, but you can't get out the apartment because there's a gate.
Great question.
Not a gate, an actual bar.
You're talking about a block window, yeah.
Yeah.
Well, REAC, until recently, and there's been a change, wants two means of egress from every room. Now, for the most part, that rule applies, and the classic example of that is the air conditioner in the first floor window, bedroom window. You're going to get cited for it, but that's where you bring in your architect, your licensed architect, you bring in the code guy or whatever it is, and you show that it's permitted by code, and you will get your points back. The recent exception to this is in maintenance rooms where residents don't normally have access and would not use them for means of egress. So for example, if you have a supply room that has one door and has a big window and it's gated, it used to be that you would get cited for that. Now you will not get cited for that because it's not something that the residents would normally use.
The apartments on the 7th floor can't get out their window, right?
Well, REAC considers a window to be a window that's used for egress if it is on the 3rd floor or below, or if the window leads to a fire escape.
Yeah.
Now, you have to be real careful about that. We did an appeal once for a building that was on a slope. The 3rd floor in the front of the building was truly the 3rd floor. But in the back of the building, it was the 4th floor because there was a basement. And the way we did the appeal on that is by taking a photograph that clearly showed this is the window, and we circled it. And it showed that there were 4 floors, including a basement that was full size. And we made sure that a picture of the basement door under the window, under that row of apartments, was shown that shows that it truly was 4 floors.
And just on that, you know that the inspector's picture would show the 3 floors if they had a photograph. So if all they had to rely on was that photograph, they'd say, well, we have a picture of the building, it's only got 3
Well,
floors.
actually, the inspector's photograph probably would be from the inside of the apartment anyway.
Or, yeah, one way or the other. But
Yeah.
that's why I think the photographs are, they cut both ways, because you can always be careful where you take the photograph from. And,
But as long as your architect can say, yeah, there's two means,
yeah,
this window is not a means of egress under the fire code of New York City.
What the inspector has to, what the architect has to say is he has to say he went to the location, he inspected it, and all applicable codes are met. I mean, he's going to go a little bit more expansive. Many of them like to get into the issue, it's a fireproof building and there are 3 sprinkler systems and 47 fire extinguishers and blah, 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 blah. And that's helpful, no question about it. But the key thing is the statement that all applicable codes have been met and that the person making that statement is qualified to make that judgment.
Okay.
That's the key issues. There's certain language which you want to make sure are inserted into the letters. So when we do appeals, for example, we get drafts from our clients of the third-party things, and we'll make some changes. And hopefully the architect or whoever it is will go along with it. We'll never ask an architect or the third-party expert to say something that's untrue. First of all, his license is on the line. But secondly, just for general credibility. I mean, all I have to do is lie once, and Jenny will never talk to me again. I mean, that's the fact. And she'd be right not to. So you want to be very careful, but you do want to include certain language that you know REAC will respond to. Sir?
Low voltage wiring, dispute of whether it's exposed wires. I mean, low voltage is not generally an item that they...
Low voltage would not be exposed wires. If it's low voltage, you're okay.
The question that I have is discrepancy between you and the inspector when it comes to a certain item.
Licensed electrician would be your third-party expert. You use a licensed electrician. And that's usually not a problem.
Yeah.
REAC will accept
that'd be
that.
easy to get.
That's an easy one. Most inspectors in our experience already know whether something is low voltage. I have had situations where we were doing shadowing and the owner swore up and down that something was either low voltage or was turned off completely. And the inspector the inspector said, check it. And it turned out to be high voltage and turned on. So, before you touch it, to prove it to the inspector, make sure you know what you're doing. As they say, ground yourself. Grab a part of your anatomy and ground yourself. Anything from the web?
We're good.
If you're going to wrap up, I have some
Okay.
closing remarks.
Any experiences anybody wants to share or any horrible things that happened to them with REAC? Well, after we finish, Bill and I will both be hanging back if there's anything that you need to talk about that you didn't want to say publicly. Although, you're certainly welcome to say it now. No one's going to say anything bad about you. Okay, thank you. Greg?
Thank you.
Thank you. Weren't they great? Let's hear it. I just got hot right off the press is the 2015 dates and for the most part the topics. Our next seminar will be January 20th. They're all Wednesdays, by the way. It's January 21st, and New York City will be coming here to do our energy efficiencies. All right. Then the next date we have is February 25th, and that's going to be something a little bit different from us. It's going to be Tax Credits 101. Because we are going to be doing a certification of people that need certifications and tax credits, probably in the spring. Then we have our famous annual regulators conference, which will be April the 29th. All right, and that's like 3/4 of a day full of everyone we can get down here, from the federal, city, and state level. Then after that, in May 13th, and then after that is June 3rd. And I really forget what we're putting on, but I know one of them has to do with the Public Service Commission. There's a whole thing have to do with, any of your buildings master metered? Well, they're all, any buildings here master metered?
Yeah.
Well, they're gonna be forcing people out of putting in sub-meters.
They're gonna be forcing them to put in sub-meters?
Yes, they are. I mean, that's where we're going. The mayor has talked about this. Public Service has been talking about this. This is where we're going. So
Co-ops as well as rentals?
yes.
And are they're gonna be direct billed through the sub-meters?
Well, yes.
So there's gonna be an adjustment in the rents?
Yeah. Well, especially with HUD buildings.
Absolutely.
Yeah. So, they're all going to be at Yale. Our one in April, the regulators, is going to probably be on the 20th floor, a much larger room. So I just wanted to let you guys know about that, and I thank you for braving the cold, all right, and coming out here. And I know, and don't forget, you have the discs and business cards, the information here, and I thank you one and all. Bye, everyone on the web.
Thank you.
Thank you.